Chapter 54 Spousal Support 1. Jurisdiction 1.1 The Divorce Act. A married spouse or a divorced spouse may apply for spousal support under the Divorce Act. Spouse as defined in S2 of the statute means either of two persons who are married to each other. If a divorce has been granted, a support claim by one of the parties must be brought under the Divorce Act because of federal paramountcy. 1.2 The Family Law Act. A spouse may apply for spousal support under the Family Law Act (FLA). Under this act, for the purposes of support, spouse is defined to include either of two persons who are married to each other or have entered into a marriage that is voidable or void, in good faith on the part of a person relying on this clause to assert any right, either of two persons who are not married and have cohabited continuously for a period of at least 3 years in a conjugal relationship, and either of two persons who are not married but who are in a relationship of some permanence if they are the natural or adoptive parents of a child. Once parties are divorced, neither may apply for spousal support under the FLA. If one party commences an application for a divorce and claims spousal support under the Divorce Act after FLA proceedings have commenced and the court has not yet adjudicated the FLA claim, the FLA claim is automatically stayed pursuant to S36. 1. Of the FLA. A party may seek leave to lift the stay if, for example, the other party commenced the divorce application in bad faith. If spousal support has already been adjudicated under the FLA, the order remains in force until superseded by an order under the Divorce Act. If after a FLA proceeding has started a party brings an application for a divorce alone without joining a claim for spousal support, both claims may proceed. Federal paramountcy is not engaged if neither party claims support under the Divorce Act. 2. Entitlement 2.1 Support principles. Both the Divorce Act, in S15.2, and the FLA in S33. 8. Establish broad guiding principles for entitlement. The courts recognize that the task under support legislation is to provide for the fair redress of the economic consequences of spousal relationships. The length of the relationship, the parties' financial circumstances, and the roles they fulfilled while together, particularly the raising of children, are all relevant factors. The language differs slightly, but the same principles apply under the federal and provincial support statutes. In Bracklow v. Bracklow, the Supreme Court of Canada reviewed the basis for spousal support claims and identified 3 conceptual models: contractual, compensatory, and non-compensatory or needs-based support. Contractual. The court will consider any express or implied agreement between the parties to create or limit mutual support obligations. Compensatory. The court will compensate a spouse who has suffered economic disadvantages as a result of the marriage or has contributed to the economic advantage of the other spouse. Needs-based. The court will consider the needs, means, and other circumstances of the spouse to determine if the spouse is able to support himself or herself at the end of the relationship without the assistance of the other party. 2.2 Conduct. Subsection 15.2. 5 confirms that under the Divorce Act, spousal misconduct relating to the marriage is not a proper consideration in making a spousal support order. The FLA provides that a court may consider spousal misconduct but only in the rare case in which conduct is so unconscionable as to constitute an obvious and gross repudiation of the relationship. S33. 10. 2.3 New relationship. The fact that a spouse has entered into a new relationship does not disentitle that spouse to support, although need may be mitigated by the new partner's contribution. 2.4 Limitations. There is no limitation period to an application for support under the Divorce Act. The same is true of the FLA Limitations Act, 2002, S16. 1. C3. Quantum and duration. 3.1 Quantum. Neither the Divorce Act nor the FLA provides specific direction as to the quantum of spousal support. Both parties exchange financial disclosure and prepare budgets showing current need and spending patterns during the relationship. The standard of living during the marriage provides the measure of the appropriate level of support. The payer spouse's means may limit the ability to replicate the pre-separation standard of living in each household. A court may impute income to a payer spouse or a recipient spouse based on the evidence. Some courts have used the income calculations in the federal and provincial child support guidelines to determine income for spousal support purposes. 3.2 Structure of the order. A final support order may be indefinite, time-limited, or subject to review. An indefinite order, subject to variation if a material change of circumstances occurs, will be made in most cases. Courts will not speculate that a recipient spouse will be financially independent within a specific time period. A court may order a time limit after a short-term marriage where there is clear evidence that the spouse receiving support will obtain employment in a known time frame, or where there is concern that a spouse is not making reasonable efforts to find employment. Under the Divorce Act, a court may order that spousal support be subject to review after a fixed period without the need to prove a material change of circumstances. Review orders are limited to situations in which there is genuine and material uncertainty at the time of the initial decision. Where a review order is made, the issues for future review should be tightly delineated. Courts have expressed some doubt as to whether a review is an available option under the FLA 3.3 temporary orders and agreements. A spouse may require temporary relief, pending the final determination of a support claim. The payer spouse may be willing to make voluntary payment of spousal support but need tax relief. Only periodic spousal support payable pursuant to an order or written agreement is taxable to the recipient and deductible to the payer. In either case, the parties may wish to obtain a temporary order or enter into an interim agreement. Temporary support is based on need and the ability to pay. The standard for temporary support is to permit the dependent spouse to live in reasonable comfort in accordance with the parties' means. 3.4 Lump sum spousal support if sufficient resources are available. A lump sum spousal support award has the advantage of permitting the parties to have a clean break. A lump sum may also be appropriate if a payer spouse presents a high risk of default or after a short-term marriage. Lump sum spousal support is not taxable in the recipient's hands or tax deductible to the payer. For retroactivity, a spouse may claim spousal support for a period before commencement of the application. Courts have made retroactive awards in cases in which the applicant did not have the means to bring the claim earlier. The respondent intimidated the applicant. The respondent's income was claimed to be less than ultimately determined. The applicant had to encroach on capital, or the respondent attempted to delay. 5. Variation. A spouse may seek to vary an existing order if a material change of circumstances has occurred that, if known at the time the order was made, would likely have resulted in a different outcome. Section 17 governs variation applications under the Divorce Act. Section 37 applies under the FLA. A court may vary a time-limited order if the expectations of the parties or the court that a spouse will become self-sufficient in a specific period are not borne out. Under the Divorce Act, after a time limit has expired, the standard for review is higher. A recipient spouse must demonstrate both a material change in circumstances and ongoing economic hardship related to the marriage. A court may also vary an order dismissing a previous claim for spousal support. 6. Assignment. A spouse may assign a support order in that spouse's favor to a government agency if that spouse is receiving social assistance. Under the Divorce Act, the spouse may assign the support order to any designated federal minister and any designated provincial minister or agency. S. 20.1. 1. Under the FLA, an agency, which includes the Ministry of Community and Social Services and a municipality, may also initiate a claim for spousal support if that spouse is receiving social assistance. S. 33. 3. Once a support order has been assigned to a government agency, the agency must be served with any motion to change the order or agreement, and the agency may become a respondent to the application to the extent of its financial interest. Family Law Rules. RR 15. 11. 12. To determine if an order has been assigned, a party or the party's lawyer may complete and send a confirmation of assignment form to the Confirmation of Assignment Unit of the Ontario Ministry of Community and Social Services. 6.1 Ontario Disability Support Program Act, 1997. Modest income support may be available from the provincial government for a spouse who is disabled within the meaning of this act. This is subject to stringent income and asset restrictions pursuant to its regulations, including loss of eligibility where there have been recent transfers of assets by the disabled spouse for less than fair market value. 7. Ancillary terms. 7.1 Cost of living. A court may make an order indexing the support payable to the Consumer Price Index. The FLA provides for this expressly in S. 34. 5. Under the Divorce Act, the court has the same authority although not expressly stated in that Act. 7.2 Life insurance. A court may order a payer spouse to maintain or obtain a policy of life insurance to secure support under SS 34. 1. I. N. K. of the FLA. A court may also order a spouse to maintain or obtain a policy of life insurance to secure support under the Divorce Act in an appropriate case. Katz v. Katz. 7.3 Binding on the estate. A spousal support order under the FLA binds the payer's estate. S. 34. 4. Under the Divorce Act, a court must make an express order that the award binds the estate aid. Interjurisdictional orders. Spousal support claims may cross jurisdictional boundaries. The Interjurisdictional Support Orders Act, 2002, ISOA, permits spousal support claimants who live in Ontario to obtain orders against payers who reside in other reciprocating jurisdictions. Similarly, support claimants who live in reciprocating jurisdictions may obtain orders against Ontario residents. The procedure under the ISOA for obtaining spousal support is the same as that for obtaining child support, which is described in Chapter 53, Child Support, of these study materials. The Ontario Court of Justice will apply Ontario support law pursuant to the FLA unless there is no entitlement to the applicant. If so, the court then applies the law of the jurisdiction in which the parties last shared a common residence. The ISOA is not an exclusive code, and a party may choose to proceed under domestic legislation where applicable. 9. Agreement. Spouses may enter into a domestic contract to resolve a spousal support claim. One of the spouses may subsequently make a claim under either the Divorce Act or the FLA to set aside the terms of their own agreement. 9.1 The Divorce Act. Under the Divorce Act, the court retains a narrow discretion to set aside the spousal support provisions of a domestic contract. A court will take a two-stage approach to exercising that discretion. The court will look at the circumstances of the negotiation of the agreement to see if they raise any reason to discount it and to determine whether the terms of the agreement were in substantial compliance with the objectives of the Divorce Act. The objectives include finality, autonomy, and certainty. The court will also assess the extent to which the agreement still reflects the original intention of the parties and whether the agreement is still in substantial compliance with the objectives of the Act. Where parties have unimpeachably negotiated a comprehensive agreement that is substantially in compliance with the Divorce Act, a court will give considerable weight to upholding the contract. Miglin v. Miglin. 9.2 The Family Law Act. Under the FLA, a court may set aside a waiver of support in a domestic contract if the agreement results in unconscionable circumstances. S33. 4. In determining this, a court will consider the circumstances surrounding the execution of the agreement, the results of the support provision, including any hardship, and the parties' circumstances at the time of the hearing. Either spouse may file a separation agreement with the Ontario Court of Justice under S35 of the FLA. Once filed, the support terms may be enforced or varied under S37. The parties may waive the right to have the agreement varied by the Ontario Court of Justice, but not the right to file for enforcement purposes. 10. Spousal Support Advisory Guidelines. The Federal Department of Justice has introduced the Spousal Support Advisory Guidelines. Advisory Guidelines. The federal government has not legislated these advisory guidelines. They are intended to be informal. In Fisher v. Fisher, the Court of Appeal for Ontario approved the use of the advisory guidelines. In so doing, the Court of Appeal provided direction as to how the advisory guidelines should be used. The advisory guidelines apply to cases of first instance. Courts will routinely consult the advisory guidelines in variation applications. However, where there are complicating factors such as a post-separation increase in income or second families, a court may determine whether the advisory guidelines apply based on the particular facts of the case. Gray v. Gray. They do not necessarily apply to payer spouses who earn over $350,000 a year, although they may be considered. The reasonableness of the advisory guidelines calculation must be weighed in light of the facts of each case, including the financial circumstances of the family during the relationship and their likely future circumstances. The advisory guidelines are akin to a summary of relevant case law on the quantum and duration of support and should be used by counsel as such. The advisory guidelines are intended to reflect and systematize the jurisprudence that has developed under the Divorce Act across Canada. The advisory guidelines propose 3 formulas. 10.1 The without child formula in relationships where the parties either did not have children or the children are no longer dependent. The advisory guidelines propose that spousal support ranges should be between 1.5% and 2% of the difference between the spouse's gross incomes for each year of marriage, including years of cohabitation, to a maximum of 50% of the payer's income. The duration of support ranges from 0.5 to 1 year for each year of marriage including years of cohabitation. Support is to be indefinite for marriages of 20 years or longer or if the marriage is at least 5 years in length and the age of the support recipient and the years of the marriage together add to 65 or more. The rule of 65. 10.2 The with child formula in relationships in which the spouses have dependent children. The advisory guidelines propose that the individual net disposable income (INDI) of each spouse be determined. The INDI for the payer is the Federal Child Support Guidelines income less child support payable, taxes, and deductions. The INDI for the recipient is guidelines income less notional child support, taxes, and deductions, plus government benefits and credits. Then the INDIs are added together. The range of support amounts leaves the lower income recipient spouse with between 40% and 46% of the combined INDI. Initial orders would be indefinite with outside time limits. The outside time limits for longer marriages are 1 year of support for every year of marriage. For shorter term marriages of less than 10 years, they are the date that the youngest child finishes high school. The with-child formula is complex and requires commercial software to calculate 10.3 spousal support payable by custodial parent as the title suggests. This formula is used to calculate spousal support payable by a spouse who has custody of children. It is a modification of the without-child formula. The payer's income is first adjusted by the grossed-up notional table amount for child support, plus a gross-up of any contribution to S7 expenses. If the recipient spouse is paying child support, the payer's income is further reduced by the grossed-up amount of child support paid, table amount plus any S7 contributions. The adjusted gross income difference between the spouses is then determined, and quantum ranges from 1.5% to 2% for each year of marriage, up to a maximum of 50%. Duration ranges from 0.5 to 1 year of support for each year of marriage, with the same rules for indefinite support as under the without child support formula. Chapter 55 Cohabitation 1. Introduction. According to the Family Law Act FLA, to cohabit is to live together in a conjugal relationship, whether within or outside marriage. In Ontario, this includes same-sex couples. Some of the indicia of whether a couple cohabit in this fashion include the obvious, such as whether they were living and sleeping together, and the less obvious and harder to prove, such as the sharing of household tasks. Usually, it is obvious and almost always admitted to. Property rights. Unlike married spouses, common law spouses have no statutory property rights. This distinction has withstood scrutiny under the Canadian Charter of Rights and Freedoms in Nova Scotia. Attorney General V. Walsh. Their claims are restricted to resulting and constructive trust claims, as well as implied trust in narrow circumstances. The usual trust principles apply. There must be enrichment of the defendant, deprivation suffered by the plaintiff, and the absence of a juristic reason for the enrichment. The bottom line is that there must be an unjust enrichment, and the remedy will be restitutionary in nature. That is, the court will endeavor to repay or reverse the unjust enrichment. The claim can be for a share in property or for money, although in most cases a monetary award will be sufficient as stated by the Supreme Court of Canada in Kerr v. Baranow. The Supreme Court of Canada has indicated that a straightforward economic approach should be used in the analysis, and the value surviving approach is the correct one. For example, if the plaintiff put money into an asset owned by the defendant and the value of that asset fell over time, the court would only award restitution to the plaintiff equal to the same proportion of the value surviving in the asset, rather than a $4 monetary award for the amount that the plaintiff had contributed. This could also mean comparing non-monetary contributions to monetary contributions in determining what proportion of the total value surviving of the asset a plaintiff is entitled to, such as where maintenance and/or improvements were made by the plaintiff on an asset that was purchased by the defendant. As noted above, the Supreme Court of Canada released the Kerr v. Baranow decision in 2011, which created a new test for unjust enrichment. The test is whether the unjust enrichment is best characterized as an unjust retention of an inappropriately disproportionate share of assets accumulated during a relationship that is a joint family venture to which both have contributed. Therefore, a common law spouse will only receive a share of assets that fall under the umbrella of wealth accumulated as a joint family venture. The test considers 1. To what extent the parties exercised mutual effort to work towards common economic goals, pooling of effort, pooling of resources, and decision to raise children together. 2. The degree of economic integration and interdependence between the parties, such as whether the spouses shared expenses and used joint bank accounts. 3. Whether there is evidence of actual intent to integrate their finances. This may be inferred from conduct. And 4. Whether the plaintiff has suffered detriment as a result of making the family the plaintiff's priority in decision-making, financial or otherwise. The Ontario Court of Appeal has indicated that courts are to avoid equalizing the parties' property under the guise of resulting or constructive trust doctrines, since the Supreme Court of Canada indicated that these statutory rights, such as the right to an equalization payment, are not to be extended to common law couples. Where common law spouses own a home jointly, one spouse may bring an application for partition and sale under the Partition Act to have the home sold, since common law spouses do not have property rights under the FLA. The case law is conflicting as to whether a common law spouse can apply for exclusive possession as an incident of support. However, they cannot apply for the exclusive possession of a matrimonial home under S19 of the FLA. 3. Support Obligations. Part 3 of the FLA deals with spousal support and child support rights and obligations. While it applies equally to married and unmarried couples, married couples will usually advance their support rights under the Divorce Act, leaving the bulk of the cases under Part 3 to common law spouses. To make a claim for support under Part 3 of the FLA, common law spouses must have cohabited with each other continuously for at least 3 years or been in a relationship of some permanence that has resulted in a child. This includes adopted children. If the period of cohabitation has been interrupted, it is a question of fact for the courts to determine whether that terminates the right to claim support. Cohabiting couples who have children must claim child support under Part 3 of the FLA. The obligation to support a child under the FLA is similar to the obligation to support a child under the Divorce Act. Both acts impose on parents an obligation to support a child who is a minor, enrolled in a full-time program of education, or unable by reason of illness, disability or other cause to withdraw from the charge of his or her parents previously. Adult disabled children of unmarried spouses were not eligible to receive support under Part 3 of the FLA after the recent Ontario Court of Justice decision in Coates v. Watson, where the mother of an adult disabled child not enrolled in a full-time program of education was granted child support. Ontario amended the FLA to make all adult children with disabilities eligible for child support. This was an important change to the child support provisions in Part 3 of the FLA for unmarried spouses. 4. Cohabitation agreements. Part IV of the FLA deals with domestic contracts and includes the provision that common law spouses may enter into cohabitation agreements that set out their support and property rights and obligations. Common law spouses may also enter into separation agreements at the end of their relationship. In a domestic contract, common law spouses could, for instance, choose to adopt the property scheme from Part 1 of the FLA if they wished. 5. Ontario Disability Support Program Act, 1997. The cohabitation requirements for a person to qualify as a spouse of an applicant or recipient of income support under the Ontario Disability Support Program Act, 1997, ODSPA, are far less demanding than under the FLA under S1, 1, of General O. Reg. 222/98. Made under the ODSPA. Two persons are considered spouses if they have resided in the same dwelling place for a period of at least 3 months, as long as the following 2 conditions are satisfied. The extent of the social and familial aspects of the relationship between the 2 persons is consistent with cohabitation. The extent of the financial support provided by one person to the other or the degree of financial interdependence between the 2 persons is consistent with cohabitation. General specifically prohibits sexual factors from being investigated or considered in determining whether a person is a spouse under the ODSPA. S1. 2. If a person is found to be a spouse of an applicant for or recipient of income support under the ODSPA, the spouse is considered a dependent for the purposes of the ODSPA. General S1. 1. This means that the income and assets of the applicant's recipient spouse are considered in determining whether the applicant recipient is eligible for income support. Under S5. 1. C. of the ODSPA, the budgetary requirements of the person under a disability and any dependents, which, by definition, automatically includes the spouse, must exceed their combined income, and their combined assets must not exceed certain prescribed limits under the regulations. Further, under S16 of the ODSPA, where the director determines that an overpayment of income support to a recipient exists, the director may recover any amount of such overpayment directly from that recipient's spouse, as defined under General, as long as the director has served notice upon the spouse, the time for commencing an appeal has expired, and no appeal has been commenced. Chapter 56 Financial